This is Bart Peterson, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Greg Gilchrist, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
This is Dan DeMarco, and you are listening to the FCPA Compliance Report on the Compliance Podcast Network.
Hello, everyone. This is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance Report. Today, I have with me Gar Hurst. Gar is a partner at the law firm of Givens and Johnston. We take a look at the biggest import control issue you have never heard of, which is wood packaging violations. Though it's a little bit outside ABC compliance, there's lots of lessons for the compliance practitioner. I know you'll enjoy this episode. Hello, everyone. This is Tom Fox back for another episode, and we go in a very different direction today as I have my good friend and colleague, Gar Hurst from Johnston and Givens, to talk about wood packaging violations. And you may wonder what that has to do with the FCPA. Well, at the end of this podcast, you will know the answer to that. So, Gar, with that incredibly long-winded introduction, first of all, welcome. I'm glad I finally got you on the podcast, and thanks for taking the time to visit with me.
Well, thanks for having me on. And you're right; it has a very tangential connection to FCPA, but and we will go there. But for the most part, this is just another huge mess that companies find themselves in. So that I've actually had the privilege, if you want to call it that, of working on the last few years. So anyway,
so maybe you could start off by telling us a little bit about the nature of your practice,
okay?
And then we're going to tie that into some compliance issues. But how did you get to where you do now?
I graduated from law school about 20 years ago and started out writing patents and found out that I really did not like doing that. And I floated around for a while, and eventually I became a customs broker and worked as a customs broker for about 2.5 years. And then I joined the firm of Givens and Johnston in Houston. And Givens and Johnston is a boutique customs and international trade firm. Our bread and butter is, working with importers and exporters who run into all sorts of issues with the government. And this was one of the issues that just started popping up about 3 years ago and has really, really hurt a lot of people.
Well, Gar, I think many of my listeners are certainly aware of export controls. They're aware of export sanctions. They have some familiarity with that from a compliance perspective, but you really focus on import. So I was wondering if you could tell us a little bit about the nature of that practice. What do you do? How do you represent clients? Who do you go in front of, et cetera?
Yeah, so we do a lot of export work, but most of my work is import related. Most of it involves, virtually all of that involves U.S. Customs and Border Protection. A lot of it involves, a biggest chunk of it probably involves making sure that people are paying the correct amount of customs duties, and when they don't, helping them sort that out in the least painful way possible. That involves filing prior disclosures and dealing with penalties and then avoiding problems ahead of time, with compliant with with rulings and giving classification advice and whatnot. But one of the functions that Customs serves is they are basically the policeman for virtually every other federal agency that ever has had anything to say about an importation at all. FDA, USDA, DOT, EPA, you name it. They all have a bunch of rules about imports, but CBP is basically the cop that enforces all these other agency rules. And the wood packing material violations stem from that. The rules are really made by the U.S. Department of Agriculture. And what they're really about is they're really designed to protect the U.S. forests. basically what they're designed to do is they're designed to stop wood boring pests that are involved in that. I mean, that are inside of wood and packing material, and there's a certain set of treatments that are supposed to be performed on wood packing material now as a part of an international convention that the U.S. joined about 15 years ago, and that is and their goal is to stop it from coming in. And if it does get through, if you violate those rules, but primarily because they find a live pest, then they really lower the boom on you because they really take protecting these forests seriously.
I think when most people think of wood packaging, they're going to think of lumber, but it's really much broader than that. Can you tell us what's covered by wood packaging regulations?
It's anything, one, that's not cargo, merchandise. It's not merchandise. But it could be bins, boxes, bracing, crates, cases, pallets, skids. It could be dunnage. It could be, if you have big metal pieces, sometimes they stick a little piece of wood in between the metal pieces to keep them from rubbing together. It includes that. It's any piece of solid wood that is included with a foreign shipment. Now, what is excluded from that list are some, or what you might think of as manufactured wood, plywood, particle board, oriented strand board, a bunch of things like this. And the theory is that whatever boring insects might be inside there will never survive a particle board treatment. They'll just be ground to dust. So that is not covered. Sawdust, wood shavings, whatever they call it, wood wool. I don't even know what that is, but that's one of the things that's outside the scope of those regulations.
You mentioned treatments. Could you maybe talk us through treatments, how they relate to this issue?
Every country in the world that has signed on to this treatment, which is this protocol, the ISPM 15 treatment, which is international. Well, I can't think of the name right off the top of my head. The ISPM 15 treatment, they have all agreed that whenever they export wood from their country, it will have undergone either a heat treatment process or a fumigation process designed to kill these wood-boring insects. And in the process, of after this treatment is done, they then the exporters are then allowed to stamp a certain marking, which is in the materials that I sent to you. It's a very distinct marking that tells what country it's from, what type of treatment it is, and who the company that actually treated it was. But they put that stamp on all the wood packing material when it comes to the U.S. or goes to any country. And so all the countries that are a part of this convention have essentially agreed that if wood packing material has this stamp, it is presumed to be properly treated and pest-free.
So what are some of the pests that are trying to keep out, or is it a family of pests? And how does that relate to the treatment and then to the products you've talked about that are subject to this regulation?
There's really about 8 different families of insects that are excluded. And if you look in the regulation, we got into some litigation about this 2 years ago, and we did a really deep dive into the regulations. And even though a lot of times they will name individual pests by genus and species, they really have the authority to exclude pests all the way up to a family level. And the list that I have is longhorn beetles, longhorn beetles and wood wasps are the 2 most common insect pests that we see. And this has been and I'm in Houston, and this has been a huge issue in the Houston area. bigger than most. In fact, it's been probably the worst affected port in the country, largely because the officers here are just really good at finding them. But so there's a bunch of the bark beetles, what they call clearwing moths, pinhole borers, bark weevils, carpenter moths, leopard moths, and one they call metallic beetles. So just a whole bunch of these. And what happens, Tom, is that the life cycle of these insects is that the adult insect will find a live tree over in Europe or Asia or wherever. They'll bore in a little bit, plant an egg. That egg hatches, and there's a larva that then lives inside that tree for several years. And basically eats the tree to survive for several years. And in the process, it leaves what they call, I think they call them cathedrals, or basically they're tunnels through the tree. And that has the process of harming the tree and weakening the wood. And it basically makes, and it can actually devastate forests in some instances.
And let me pick up on a point you raised, which is about the inspectors. How do they determine any of these insects are present? Is it a physical inspection? If it is a physical inspection, what can be a violation if insects are found present?
That's where the rubber really hits the road, Tom, and that's where it gets really harsh for importers. So you're an importer. Let's say you're an importer from Germany, and you send over your cargo, and it's got some wood on it, and there's some agriculture inspectors that work for customs, and they're just riding around, snooping around the ports all day, and they'll go and look at a shipment, and they go and they look for wood. There are some kind of telltale signs of these pests being there. And even if the wood's treated, they start looking for these telltale signs. And then if they think they see one, they just kind of pry the wood open. And if they find a live insect, which they do, then they pull it out. And the presumption at that point is that it's one of these prohibited pests. I mean, because clearly it's bored into wood. And then what they do is they will take this pest, they document it, and they issue an emergency action notice telling you, putting you on notice that you've got a real problem. But then they get the pest and they send it to a USDA lab. And the USDA has their own staff, which then confirms that these are, in fact, pests of concern.
But is this the point where you get a phone call that a client's been issued an emergency action notice and they need your services sort of immediately?
Typically, yeah. Typically, the customs will issue these emergency action notices. It usually will go to their customs broker first. Custom broker passes it on to the importer. And the customs broker at this point knows, hey, you got a real problem. You need to call someone. In the Houston area, a lot of people have started calling me just because I've handled more of this than probably anyone in the country at this point. But what happens is the first thing that customs will insist that be done is that the importer do a protective that they basically put a tarp over all the cargo. Well, that's easy enough if you're talking about a container load of stuff. You hire a fumigator. The fumigator comes out with this plastic, and they basically get some plastic and cover everything over and weight it down. But where this really gets tough, Tom, is in Houston. They've not only been going after the container ports, they've been going after the project cargo. the big shipment that comes off the general, the break bulk ship, and may have, we had one in 2018 that had 400 pieces. 400 pieces of cargo is worth nearly $40 million. They found really 2 bugs and ordered us to export the whole shipment. And that is really a nightmare situation. In that case, I think it cost my client millions of dollars because they found these insects in their cargo. And we had to do all sorts of crazy things to remedy the situation as well.
Let me pick up on a term or ask you to define a term you used, and that's called exportation. What does that mean in the context of trying to remedy an emergency action notice?
In this that's a good question. Export can mean a lot of different things depending on the context. In this context, it means get it out of the United States. And at this point, when we first started seeing these, initially they said we could not send them to Canada or Mexico. And we weren't really sure where they were coming up with this restriction. It wasn't clear to us. Obviously there was some concern that they'd find their way back in the United States, but we thought maybe it was a NAFTA prohibition. Well, we were never really sure. But in the final analysis, it was just something it was a knee-jerk reaction. So at this point, customs line, at least in the Port of Houston, is we don't care where you send it. It just can't stay here. Kind of the old bar line, don't have to go home, but you can't stay here. So
after exportation, is there fumigation? Is there repackaging? Is there some attempt to save the cargo and reintroduce it to the Port of Houston as an import, or is the cargo just now it's valueless in the United States?
The cargo, when they force you to export the wood packaging material, the problem that you have is they don't allow fumigation here in the United States. They don't allow any remedy in the United States, essentially. They don't allow what in customs lingo is a manipulation, where you can just, open up the crate and take the cargo out and then ship out the wood crate. They don't have anything like they don't allow a fumigation in the United States. So you have to ship the crate, the wood packaging material and the cargo out of the country. Once you're out of the country, you're basically subject to the laws of those foreign countries. For what it's worth, you could also theoretically do this in international waters. We've just never really found a situation where that was practical.
It seems to me that there's a remediation cost, which is to ship it out, get it fumigated, repackage. Are there also fines and penalties that can be levied against an importer as well?
There is, and they have issued penalties up to basically the value of the cargo. So in the one case I was telling you about, up to $40 million. Now, since that has come out, Customs has issued mitigation guidelines where they can knock that down to between 1% and 10% of the value of the cargo. And that seems to be the most common way of dealing with it. And then there are other defenses we can make. One thing I forgot to mention, one bit of success we have had in keeping things from being exported is sometimes, especially in the project cargo realm, some pieces don't have any wood. So, for example, let's say you're talking about a giant reactor vessel. Okay. In the Houston area, we get giant pieces of cargo coming in all the time. And the giant piece of reactor vessel, maybe, 200 tons or something like this. And it doesn't have any wood anywhere near it, but it may have railings and staircases and struts and all sorts of ancillary equipment. And that's in the that cargo is held is packaged in wood. One big success we've had is we've been able to get customs to separate a bill of lading so that if you have some pieces of cargo that don't have any wood on them, they don't have to be exported. And when you start talking about making emergency logistics operations for, really huge shipments, shipments that even with time and planning maybe took $1 million, if you can suddenly take the biggest, most difficult to handle pieces out of the equation, you can really save a lot of money. But back to the penalty question. Sorry for the diversion. But as for the penalties, that is something that we've had instances. We've had a couple opportunities to defend, and they have been mitigating them down to between 1% and 10% for a first violation. After that, I believe it's 10 to 25% is the mitigation. There's also there was one unpublished decision where customs decided that it would be the value of the packing itself and not the cargo that would be the basis for the penalty, but I'm not sure if that's going to be applied across the board.
One of the things in my world is obviously a compliance program to prevent a violation from occurring. Are there any steps a company, an importer can take to help prevent having this type of violation, or do you counsel companies along those lines to help prevent a problem from actually becoming a violation?
As I put in my the title of the presentation I gave to you, it's really the biggest problem no one's ever heard of. Everyone knows that there's a stamp, but no one really knows what it means. And the problem you got is it's never a problem until it is. And then so what an exporter needs to do is they need to really inspect this wood packaging material as though they need to have a compliance program for that, just like they have for everything else in the world. They need to inspect it. They need to audit it. They need to have a term in their contract with the export packer saying, look, if we get ejected if we get denied entry into a foreign country or get hit with a penalty because of your wood packing material, you got to indemnify us for it. And one thing that complicates that is complicated thing that so far for exporters to the United States is that U.S. Customs and the USDA have been, you wouldn't think it, but they have been almost terribly unwilling to hand over evidence that they actually found the bug. And then what ends up happening is the European exporter, they're trying to sue their packer, and they go to the European court, and the European court says, well, show me a picture of this bug. Well, then you have to go through a FOIA process, a Privacy Act process, and they'll take 9 months to turn around and give you some pictures. And they may have one photo of the thing. And even though we've told customs of this problem and how really they could, if they would just hand this information over to us, we would hand it over to our client, who would then go sue these wood packing materials. For some reason, they just don't want to do it. They just, they don't see that as their job, and it's go figure, government.
So, Gar, is there a particular reason this controversy or problem is centered in the Port of Houston as opposed to perhaps other ports in the South or even in the rest of the U.S.? Like
I said, one thing, the guys, hats off to them, the officers in the Port of Houston who are enforcing it. They're just really good at finding bugs, for one thing. They also have that also in Houston, I guess, I don't know if this is true all over the country, but in Houston, like I said, they focused in on the project cargo. And it's one thing if you have a, $20,000, $30,000, $40,000 shipment of cargo in a container get turned around. you just put it back in the container, Hapag-Lloyd or Maersk or MSC just takes it back, right? But when you have, when you've chartered a vessel from Rotterdam, for $1 million to get your, 200-ton reactor vessel here, and now they tell you to turn it around, you got a real problem. And so it's in addition to them maybe finding more, it's just the scale of what they found has been bigger here. It may be happening in other ports. I've just heard and I know it does happen in other ports as well. It's happened a lot here. And I've been here, so that's, how I've been dealing with it.
Well, Gar, unfortunately, we are near the end of our time, but I was wondering if our listeners wanted any more information on either your practice or this issue, where could they go?
I guess they could go to our website at GJA Trade Law, or I guess they can call my number. I'll just give you my number right now, if that's okay. And I'm going to give you my cell number because that's what I'm answering at this point. I'm working from home. 713-253-1679. The issue is the same across the state, across the country. And one thing we have been able to do is we actually have worked out, we have got basically a team on the ground in Altamira, Mexico now that we worked with 2-3 times to help remedy some issues where some shipments that were exported from the United States, and we've had good luck with that. So the issue you have is one of time versus cost. Probably the cheapest thing to do is to ship everything back to your port of origin. In most cases, that's going to be the case because you're going to, your packer can do it. You've got whatever. You've just got more resources there. However, in some cases, especially with project cargo, you've got to have the stuff today or next week, or some bigger contract is going to fall through and you've got a much bigger problem. In which case, Mexico has worked out well for Houston. It's a 2-day sail to Mexico versus about a month and a half back to Europe, or even longer to Asia.
Gar, this has been actually a fascinating look at a lawyer, you, who do work after the compliance failure occurs, and what the cost can be, what the steps you have to take, and how even in your position as counsel, you're counseling clients that they need to have a compliance program in place. So I wanted to thank you, and I look forward to continuing the conversation.
Thanks, Tom.
Hello, everyone. This is Tom Fox. Thanks again for listening to this episode of the FCPA Compliance Report. I've linked to the K2 Intelligence Fin website and then 2 resources, a white paper and a client alert that they put out around the fins and paper. So check those out in the show notes. This presentation of the FCPA Compliance Report has been a part of the Compliance Podcast Network. This podcast is also a proud member of C-Suite Radio. Thanks so much for listening, and I look forward to visiting with you again soon.